Skybridge.
Thank you, Your Honor. We're before you today on State versus Jerry Karpovich, files 23 CR 794 and 23 CR 1133. We're here today for sentencing. State of Ohio is prepared to go forward. Thank you.
Botany.
With regard to sentencing, Your Honor, we would just ask for any type of leniency with regard to sentencing. I know one of the issues that was sent for remand was regarding the affidavit of indigency. My office did have an opportunity to receive an affidavit of indigency in both cases that were described to be completed, and that has been filed with the court on the 23rd, which was yesterday. With regard to Mr. Karpovich and what he has been doing since he's left CNU, Your Honor, from my understanding, he has maintained sobriety. He has been a student at Marion Tech. He's made the dean's list. He actually received a 4.0 with regard to the studies that he has been ongoing. And he is also a tutor at the prison for anybody with trying to obtain a GED. Additionally, Your Honor, he has completed a CDL class. Such documentation has been provided to the court regarding all the endeavors Mr. Karpovich has completed while he is staying in prison. Additionally, there's been letters submitted from family on his behalf, and I know Mr. Karpovich would like to speak to the court as well when deemed necessary. Thank you.
All right, Mr. Karpovich, what do you want to tell me?
I want to apologize to the court, the state, the probation department, my community, and my family for my words, my words, choices, and actions during my drug use from 2022 to 2024. I suffered from extreme drug-induced cognitive dissonance. My perception of reality was so warped, I refused to show any remorse. Take responsibility or accountability for my choices. Over the past year, I've reread my transcripts multiple times. And each time I do, I'm dumbfounded on how ridiculous I sounded. You can only imagine what I wrote on my pre-sentence investigation, including my words to Ms. Wagan from probation. I can't believe I behaved in that manner, and I'm truly ashamed. I'm not only using my words to apologize, but a wise person once told me that a true apology isn't about what's said, it's about changing the behavior in which warranted the apology. So I did. I did something about it. Your Honor, your words at sentencing stuck with me, and I quote, "The reason you don't do anything about it is because you don't do anything about it." So I did something about it. I was arrested February 17th, 2024. My sobriety date is February 18th, 2024. So I've maintained sobriety just over 2 years now. I just hope the court accepts my apology, along with my community, my family.
Thank you. Ms. Winter, as I understand it, the purpose of the remand was to, in the mind of the Court of Appeals, to tell Mr. Karpovich that the aggregate sentence is actually 8 years to 11 years. Is that correct?
Yes, Your Honor. The 11th District Court of Appeals remanded for limited resentencing with respect to indefinite sentencing, which includes the total definite and indefinite term imposed, and as well as the advisements under Reagan-Tokes, my understanding, based on the court's opinion in paragraph 49, they expect those advisements to be provided as well as the total aggregate term under Reagan-Tokes.
Even though adding 24 months to 6 years and 24 months and 9 years isn't really accurate, since the sentences on the smaller cases identified in months. So I will note for the record that 24 months is equivalent to 2 years, since that was the sentence on 794. So the sentence that I'm going to impose then, which was imposed previously on, which is imposed right now, is 24 months on 794 and 6 to 9 years on 1133. The aggregate sentence for those two separate cases is 24 months plus 6 years to 24 months plus 9 years. So that is the aggregation I believe the Court of Appeals was looking for. Is that your understanding, Ms. Winter?
Yes, Your Honor, that is my understanding.
The mandatory fine that was imposed is waived pursuant to Ms. Novotny filing the affidavit of indigency. Pursuant to Revised Code 2929.144C, it is rebuttably presumed that the offender will be released from service of the sentence on the expiration of the minimum prison term imposed as part of the sentence, or on the offender's presumptive earned early release date as defined in section 2967.271 of the Revised Code, whichever is earlier. The Department of Rehabilitation and Correction may rebut the presumption described in Division B2C1 of this section if, at the hearing held under 2967.271 of the Revised Code, the Department makes specified determinations regarding the offender's conduct while confined, the offender's rehabilitation, the offender's threat to society, the offender's restrictive housing, if any, while confined, and any offender's security classification. If, as described in B2C2 of this section, the Department at the hearing makes the specified determinations and rebuts the presumption, the Department may maintain the offender's incarceration after the expiration of that minimum term or after that presumptive earned early release date for the length of time the Department determines to be reasonable, subject to the limitations specified in section 2967.271 of the Revised Code. The Department may make the specified determinations and maintain the offender's incarceration under the provisions described in B2C1 and 2 of this section more than one time, subject to the limitations specified in 2967.271 of the Revised Code. If the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. Ms. Winter, anything further that you see to satisfy the Court of Appeals?
No, Your Honor, thank you.
Mr. Guybridge?
No, Your Honor, thank
Ms.
you.
Novotny?
No, Your Honor, thank you.
All right, we're adjourned.
All right.